Yes, you can start now, Umal.
Thank you. Good afternoon, Your Lordships. I welcome you all to the final round of the first Intra Moot Court competition at Jamia Hamdard. With your due permission, the councils would now like to proceed with their arguments.
Yes, they can.
Before starting my argument, counsel would like to seek permission to call the bench collectively as a lordship.
Yes, very well.
Much obliged, lordship. The council will begin in 3, 2, 1. May please this honorable court. I am counsel Speaker 1 of Team Code K, appearing on behalf of petitioner in the case of Rights of People versus Union of Selexa and others. If your lordship is well versed with the facts of this particular case, may I proceed my first contention. Prior to starting my submission, I would like to provide a brief map of my contention. I will be dealing with two major contentions. Firstly, the petition filed by by the Rights of People is in nature, and secondly, the MHA order that led to migrant access was arbitrary, disproportionate, and violative of their fundamental rights. Now, before begin with my further submission, counsel seek permission to start with my argument.
Counsel, can you tell us facts very briefly in a minute?
Certainly, Your Lordship.
Yes.
Your Lordship, the country of Alexa, a developing country located in South Asia with the second largest population and the sixth largest economy, got struck by the highly transmissible and deadly virus known as COVID-19. However, on January 2020, nation witnessed its first case. Slowly and gradually, virus had spread rapidly across the country with approximately 5,500 infections and 150 deaths. But on 24th March 2020, the Prime Minister of Selexa announced a nationwide lockdown for a period of 21 days and imposed on 25th March 2020 onwards. While its order issued by the Ministry of Home Affairs (MHA) as infections continue to surge, MHA through its order extended the nationwide lockdown until 30 May 2020. Now the migrant crisis was into affected. As a result, a number of hardship had faced by the people of country, especially the migrant workers who were seen long distances back to their hometowns and villages. A number of migrant workers are reported to have died. On 1st June 2020 onwards, reopening and unlocking began in a phased and a gradual manner. PIL filed before the Honorable Supreme Court. The aforesaid restriction imposed by the central government of Selexa and its state resulted in a huge public criticism following a new regulation issued by the central and state of Selexa and NGO Rights of People filed a writ petition in the form of PIL before the Supreme Court of Selexa challenging the same.
All right.
May I proceed with the further argument?
Yes, if my brother judges have nothing to ask for, yes, I think.
No, you may proceed.
Much obliged, Lordship. Now, the first contention of my issue, the present public interest litigation (PIL) is maintainable. The bar and the litigant public has been tolerant for so long, but this bench cannot be remain a silent spectator waiting for inevitable error to explode. It is humbly submitted before the apex court.
Counsel, I would like you to pause here. Please pause here. You don't need to read your memorial verbatim.
Much obliged, Lordship. Certainly.
Yes.
The concept would like to unfold the three grounds of a maintainability.
Please tell us how is the PIL maintainable? Yes.
PIL would like to clarify with my further argument that the PIL is maintainable with three ground reasons. That is, the said petition has a request site locus in standi, and the petitioner has public interest at large, and it exhausts the alternate remedies. And although along with that, it has infringe of the fundamental rights.
Oh, that's right. Tell us, who are you?
I am the petitioner.
No, you are the petitioner. What is you are an organization. You are an individual. What are you?
Lordship, could you please clarify your question so that
are you an individual? What is the status of the petitioner? Is the petitioner an organization or is the petitioner an individual? What are you?
The present petition is filed on behalf of the organization, Your Lordship.
All right. So, what are the issues you are trying to espouse, and how are you? You tell us.
the deadly transmissible virus COVID-19 was spread across the nation. So it's not a specific individual person suffered by this virus. It was witnessed across by the nation.
All right.
So this is how it comes in the form of the PIL.
All right.
If your lordship is satisfied with your question,
Yes,
may I proceed further?
please go ahead.
Much obliged, lordship.
Oh,
If
counsel,
public duty,
no, counsel, I just want to know that is there any case registered of where you can say that there is a violation of fundamental right? I mean, do you have
indeed, your lordship, if
Yeah.
you could please permit me to answer this question in my further submission.
No, why would you want to go? Why would you want to delay the bench? I mean, I want the answer right now.
Indeed, your lordship. The petition has been filed considered there is a case of the Bandhua Mukti versus Union of India. Justice Pathak observed very clearly that the petition has been filed considering the adverse effect of this legislative act on the fundamental rights of the citizen of Selexa. Additionally, the petition has been filed with a bona fide intention. Since no personal or political benefit is being apprised through it, therefore the petitioner has the requisite locus standi, and notwithstanding this and many other judicial strategies and aim at simplifies locus standi in PIL have earned Indian judiciary the name champion of public interest litigation. Your lordship.
No. The counsel, you actually misunderstood my question. What I'm trying to know that what are the grounds? What is there any violation? Is there any violation of fundamental right registered? Do you know that there is there any case which has been reported on this in this particular ground that's why you are going to the court, right? Otherwise, why do you think that there is a fundamental right? On what ground you are saying that there is a violation of fundamental right? There has to be some concrete ground, right? Otherwise, you label it as a premature. Yeah. Yes.
Would like to clarify with the answer, with the specific in respect to that, would like to clarify my answer for the Moot proposition itself, where in para number it's already mentioned that the migrant of workers were reported to have died.
Yeah.
There is a violation of Article 14 and 19 as well. Along with that, Article 21.
No, that's right. But how do you connect it to the act of central government imposing lockdown? How do you connect?
Because it's if the legislature passed by the Ministry of Home Affairs, lordship.
No, so why did people walk? Why did people travel? Why did people decide to travel?
The answer clarified in the Moot proposition itself, where the central government passed an order on 24th March 2020.
The central government imposed. Okay, listen to me. Okay, have some patience. The central government imposed the lockdown, right? The central government imposed the lockdown because the virus was spreading, right? It was contagious due to its contagious nature, right? The central government did not tell the residents. The central government did not tell the citizens to travel. Why are you connecting these dots? I want to know the relevance.
The central government can connect. The understand your concern, your lordship. The central government can do so, but it should be in reasonable cause with the reasonable effect.
So, what is the rational nexus? I want to know the.
Your lordship, that's if you kindly me permit, that will cover in my second intention of the issue.
I think, counsel, you didn't understand the question of my brother judge. What he was trying to ask is, central government imposed a lockdown and asked people to stay put wherever they are. They should stay there. They shouldn't travel. So by imposing such lockdown, why did people travel? That was not a mandate of the order. The order didn't ask the people to travel, to walk. So people violated the order on their own. How is central government to be blamed for that?
See, I ask you a simple question, counsel, that I said that why do you think that there is a violation of fundamental right? You said that because people died on roads, right? Because of the imposition of lockdown. I said that why, if there is a imposition of lockdown, then what is the connection of people traveling for such long hours, that by walking, right? By taking a walk. So what I'm trying to ask you a simple question, that is there any, I mean, is it mandatory to travel by walking? I mean, of course, it's natural. People would exhausted and people would die. Are you getting my point?
Indeed, your lordship.
Yes.
Your Lordship, Council would like to clarify that that relevance, public at large will want to satisfy their basic needs.
All right, I think
that were all.
I'm sorry.
Needs
I think we
what?
should proceed, Council.
Much obliged, Lordship.
Yes, proceed.
Your Lordship would like to Lordship. PIL is to be used as an effective weapon in the army of law for delivering social justice to citizens. The attractive brand name of public interest litigation should not be used for suspicious products of mischief. It should be aimed at a redressal of genuine public wrong or public injury and not publicity oriented or founded on personal vendetta. Now, it's already observed in the Fertilizer Corporation Kamgar Union versus Union of India in 1981 judgment, which says that public interest litigation is part of the process of participatory justice, and standing in civil litigation of that pattern must have liberal reception at the judicial doorsteps. Now, Council would like to the second intention from the observation of the judgment Bandhua Mukti Morcha versus Union of India. A PIL serve to enable litigation.
Council, please tell us, where are you reading it from? Have you cited these judgments in your memorial? Please take us to the relevant page.
Your Lordship would like to refer the page number 21 at para number 11.
Yes, that I have seen, para number 11. Para number 13 is the judgment you were referring to, Fertilizer Kamgar Union versus Union of India. So the next judgment, Bandhua Mukti Morcha, where have you cited it?
Your Lordship, itself in the page number 21.
All right. Where? We can see you have cited many judgments. So you have to take us through the relevant pages of your memorial. Next judgment, Bandhua Mukti Morcha, where have you cited it? Yes, I can see it's in the footnotes on page 21. But we can't see any assistance from the council. It's footnote 32, I believe. But it's without citation.
Yes, I wonder which form of referencing you are following.
That's right. It's not with citation. It's N28. What does N28 stand for? Council, can you please clarify what does N28 stand for? It's at footnote 32 of page 21.
Who's your researcher? I would like to talk to your researcher. Team K researcher, can you come up? Don't you have a researcher?
Yes, the researcher we can see here.
Yes, sir.
Yeah, which citation you followed?
Sir, it has been mentioned in the index of authorities, in which we have mentioned the cases at first, and at number 12 I have mentioned about Bandhua Mukti Morcha versus Union of India, 1984 3 SCC 161.
No, but on page 32, what you have cited? What is the mode of citation? What is the mode of citation? You just explain and go.
Dr. Farooqi, I think they have mentioned the index of authorities. There, the citation is there. It's at number 12. That is what I think I can.
Yes, they have mentioned it in the
Yes.
initial pages of the memorial,
Yes,
but what they did not. But what I'm trying to note, even if they're referring to the initial cases, they need to know that what they mentioned at the page number 32. I mean, you brought it up.
Sorry, sir.
Right.
Sorry, Your Lordship. I want to mention here that I would. It's a mistake here. I wanted to cite the N25, and you can see at footnote number 25 I have mentioned the same case with full citation.
Yes, Justice Pathak, Bandhua Mukti Morcha versus Union of India at 25 as well. Anyway, you can proceed, counsel, with your further arguments. So please take us to the relevant pages wherever you are citing any judgment.
I seek apology, Your Lordship. May I proceed further?
Yes.
Any member of the public or social action group acting bona fide can invoke the writ jurisdiction of the High Court or the Supreme Court seeking redress against the violation of a legal or constitutional rights of person who, due to social or economic or any other disability, cannot approach the court. Parallelly, PIL became an important weapon for the enforcement of the public duties where executed in action or misdeed resulted in public injury. And as a result of any citizen of India or any consumer groups or social action groups can now approach the apex court of the country seeking legal remedies in all cases where the interests of general public or a section of public are at stake. It referred in the page number 22, para number 14 and para number 15.
Yeah, that's right. But again, I asked you initially as well, you don't need to read verbatim. You have to, that's not how you argue. You have to, of course, you can cite certain paragraphs from relevant judgments, but what is the point you are trying to make?
Your Lordship would like to clarify that public litigation can be filed with the grounds of locus standi.
Oh, that's right. We get it. But applying it to the facts of present case, how is this PIL maintainable? I mean, these are policy decisions of the government. How do you bring them under a PIL? Wherein you are on one hand claiming that there are a lot of people who have suffered. None of them have approached us.
That's Lordship would like to that relevant to that reference. NGO rights of people came into the front and approached the Supreme Court.
No, but why not the people who have suffered?
To that extent, Your Lordship would like to refer para number 7 of the memorial itself, where one of the person suffered the same case, but it's not compulsory and sufficient that other people cannot get affected of it.
No, that's right. You're talking about the vaccine issue. Paragraph 7 is about that.
We are still dealing with the first issue. That's the problem.
Yeah, but he's referring to paragraph 7. It's, I believe, related to the person who has been administered vaccine, or he's supposed to be. Is that what you're referring to?
I agree, Lordship, but that contention of the issue will deal with my co-counsel.
No, that's right. But that person can approach us directly. Why through you? He can file a PIL himself, or he can file a writ petition himself.
Because, Your Lordship, a certain group of people also suffered the same cases.
All right, please proceed.
Much obliged, Lord. During the last decades, public interest has compelled this court to consider issues relating to environment, social justice, violation of human rights, and disregard to Article 21, either because an absence of governance due to failure of a state to faithfully and sincerely implement enacted by Parliament, or due to nuance of government by the state, that is central government, the state government and union territory administration, leading to rampant illegalities. The failure to the state to take remedial steps to fill in the gap where there is no operative law, except that enshrined in the Constitution, more particularly Article 21, has resulted in public interest litigation and at least 2 cases where a written obligation ought to be fulfilled.
Sorry, counsel. Which issue you are dealing with? You are dealing the vaccine issue. Which issue you are dealing with?
Issue number 1, whether the PIL is maintainable or not. Your Lordship. If Your Lordship is satisfied with my argument, I would like to move further with this third contention of the issue, that the present petition had a state representation and existence alternate community is not a bar under Article 32.
Yes.
Much obliged, Lordship. The Indian judiciary, considered to be the most active in the world, is credited to have been pivotal to the development of robust standing rule in discharge of its duties. This honorable court must act as a sentinel on the queue way, which means watchful guardian, and ensure that the fundamental rights of the citizens are protected zealously and vigilantly. Furthermore, would like to highlight my argument from the SP Gupta versus Union of India, which were also filed by the PIL by the petitioner, and Honorable Justice Bhagwati observed that providing access to justice for large masses of the people who are denied their basic human rights it can only be achieved if the people who are denied their basic human rights, and it can only be achieved if the court adopts innovative new methods and devices new strategies. These strategies and methods have been coined to mean social action litigation in India. Further, it would clarify with the my lines of argument would clarify with the People's Union for Democratic Rights versus Union of India in 1982 judgment, where court observed that in a recent development, an apex court saw itself having an obligation to secure justice for the poor and weaker sections of the community and to promote or vindicate the public interest, which demands that violation of constitutional or legal rights of large number of the poor, the ignorant, or those in a socially or economically disadvantaged position should not go unnoticed or unaddressed. No, again, the observations of the Bandhua Mukti versus Union of India by the Honorable Justice Pathak, it observed that and clarified that in the areas of judicial functioning where judicial activism finds room for play, where constitutional adjudication can become an instrument of social policy forged by the personal political philosophy of the judge, this is an important consideration to be kept in mind. And the last contention of my argument.
Counsel, we appreciate the judgments which you are citing. There is no dispute regarding them. Now, how do you apply these judgments to the facts of this case?
Your Lordship would like to present the facts of that judgment, if you kindly may permit.
No, that's fine. We understand the facts. Now, the ratio you are reading. So please apply these judgments to the facts of this case. How do they support your case?
Your Lordship, in that judgment, the public interest litigation was filed via Article 21 of the Indian Constitution directly before the Supreme Court of India and petitioned that the court to direct the state of Uttar Pradesh to take steps to end child labor. And this case, along with other public interest litigation cases on the issues of child labor and a range of child labor eradication campaigns, have been successful in raising awareness about the.
All right. So, what are you asking there in your case?
Your Lordship, the similar cases were reported in the present case as well, Your Lordship.
No, what are you trying to seek by way of this public interest litigation?
What is the relief you're seeking?
To get compensation of the migrant worker who got suffered in the present case.
Oh no, how can we? They are not before us. How can we decide compensation? I don't think so. That's your prayer in the first place.
Your Lordship, I seek apology, but that's a argument, and it's already been cited in the prayer as well.
Oh, that's. I don't think so. That's the scope of this petition from the facts. That's not the scope. Anyway, what else?
If Your Lordship is satisfied with my argument, would like to move to the next issue.
Yes. What is the next issue?
The MHA order that led to migrant crisis was arbitrary.
Yes.
The petitioner Humble argued that firstly, the MHA order which led migrant crisis is arbitrary and disproportionate to the amount of compliance with constitutional mandates, and secondly, that the state action proceeding from the same amount to violation of fundamental rights, exposing gross injustice being meted out to the helpless worker.
Oh, where is this issue you have dealt with in your memorial? Please take us to the relevant page. We have been asking you again and again. Please take us to the relevant page.
Just give me a moment, Your Lordship, if you may kindly permit.
Yes.
Much obliged, Lordship. Your Lordship, page number 33, para number 1.
All right, please proceed.
Obliged, Lordship.
That's
Article 19.
All right, so you have skipped issue number 2. That will be dealt by your speaker number 2, I believe.
Indeed, Your Lordship, certainly. That will be dealt with my co-counsel.
All right.
Much obliged, Lordship.
So why can't you deal the second issue?
Your Lordship, because counsel believe and counsel do believe that issue number 2 and issue number 4 are related with each other.
No, I want.
Regarding the.
Are you are representing a client right here? So I want you to deal the second issue. You should be well versed with the case. You should be well versed with the relief which you are seeking, right? So I want you to deal the second issue.
Counsel have no objection with this, Your Lordship.
Okay, thank you.
Council would like to proceed with my submission.
Yes.
Your Lordship, if kindly permit, can I conclude my ongoing issue number 3?
Yes, yes. If my brother judge has
Much.
no.
Lordship. Article 19, Clause 1, Subclause D guarantees to all citizens the right to freedom of movement. Rights enumerated in Article 19, Clause 1 are those basic rights which are recognized as the natural rights inherent in the status of a citizen. Hence, a law restricting the exercise of any of the rights guaranteed by Article 19 to be constitutionally valid must satisfy two conditions. Firstly, the restriction must be for the particular purpose mentioned in the clause permitting to the imposition of the restriction on that particular right. Secondly, the restriction must be reasonable. Now, the imposed restrictions are reasonable. Why do council believe this? The phrase reasonable restriction connotes that the limitation imposed on a person in enjoyment of the right should not be arbitrary of an excessive nature beyond what is required in the interest of the general public. Thus, in balancing the competing interest of public and compromises on the rights of the victim of
That's
such
right,
state
council. Now,
action
please
in
tell
the,
us.
to be
We
introduced.
We understand that. Please tell us, how is the MHA order violative of Article 19?
Indeed, Your Lordship, in the instant case and the present case, the MHA order issued to prevent COVID-19 transmission and death. However, it is imperative to be noted that the restriction imposed were unreasonable without maintaining a proper balance on its adverse effect, that it left workers with effectively no choice than succumbing to a deadly virus or starvation.
No, that's not
Furthermore,
enough. You saying that it was not reasonable. Please tell us how it was not reasonable. It's not enough just to say it is not reasonable. How it was not reasonable?
See, what I want to understand is what is your grievance? What is your grievance with the government action? What do you want the government to do?
The MHA order was passed. The council do believe, Lordship, the MHA order was passed is arbitrary and disproportionate in the present case.
No, we can understand how is it arbitrary? How is it arbitrary? Why do you say that it is arbitrary? On what grounds do you
because of the violation?
What is your difficulty? Like, what difficulty do you face with the government action? Do you expect them to sit idle?
Your Lordship, the council believes. Your Lordship, the council understand your concern. It is because the MHA order is in violation of Article 14.
No, make me understand, what does the government do then in that case? What would you have do then? What should the Lordship do?
Your Lordship, that will be raised in my prayers.
Wait, like this.
Okay.
Answer it right away.
So, council, see, the thing is that what you are seeking, see, we are not seeking any kind of alternative that what could they have done or what should they have done, because you are not a policy maker. You are here coming as a council, and what you are seeking from us the relief. So we can understand your situation, but the thing is that you are saying that that action or that order was unreasonable unreasonable because under Article 19. Okay, this is what you are saying, but on what grounds? Because if I buy your argument, then all the actions, all the restrictions put on the people when when people who have that kind of a disease which is contagious in nature, right? Or all the restrictions which is being put on the people who have done something criminal, right? So, what I'm trying to tell you, the restriction which has been put in the name of public order, decency, or security, that would be wiped off. So what you are saying here, it could be very dangerous in nature, right? You want us to take the action against the national security or maybe a public order, right? So you want to delete that particular provision from the Indian Constitution? Is this what you are challenging? So you first challenge the constitutionality of that particular provision or Article 19, which the reasonable restriction which mentioned, right? Because every action, those freedoms are subjected to reasonable restrictions. We understand that people died, but what you need to understand that if that kind of a virus, which is that much contagious, is spreading at a high rate, then you need to understand that what states need to do, right? So why you are challenging this, on what grounds? So that the consequences of that order is that that people died. So yes, I mean, we are not telling you to tell us the alternative. What we are saying that on one grounds you said that. Are you getting my point? So tell us the grounds.
Indeed, Your Lordship.
Yes.
Your Lordship, the council understand your concern and do understand that state has some power to take reasonable action to control this highly transmissible virus, and the grounds that council stands is equality. Equality is a basic feature of the constitution, and therefore bars state machineries from transgressing the same. The Supreme Court has propounded equality as antithetic or arbitrariness when an act is arbitrary.
Please pause. Your time is up. We can see in the chat box.
Yes.
Your Lordship, if you may kindly be permitted, I would like to conclude my further argument in
Please conclude in 1 minute. We have to stick to the time. Yes.
Much obliged, Your Lordship. When an act is arbitrary, it is implicit in that it is unequal both according to political logic and constitutional law, is therefore in violation of Article 14. No further submission. If the order is arbitrary for the unbridled administrative discretion, its order. It is maintained that MHA order which led to migrant crisis and its scarcity across the nation and hence fails the test of Article 14. The MHA order confers wide discretionary power to the state machinery to effectuate the order which lacks any sound in guidelines. By sudden suspension of the legislation goes against the legitimate expectation for the migrant worker. The impact of the
okay, counsel, end this on your argument. I want this your argument, and please don't read. Okay, stop reading. And this is an advice to all the council. Right. What I'm trying to ask is that what is your argument? What is your line of argument if there is a conflict between fundamental freedoms and and national security or public order? Which one shall prevail?
Your council would like to clarify that always fundamental freedom shall prevail.
Shall prevail.
Much indeed, Your Lordship. Certainly.
Is there any debate? I mean, is there any popular judgment or a popular scholarly debate on this? If you have a
Your Lordship, Supreme Court itself delivered a judgment in Shri Nivasan versus Union of India. That where there is a conflict between fundamental rights in any of the rights, there always fundamental rights shall be prevailed.
I'm not saying. I'm saying fundamental freedoms and the national security or the public order. Which one shall prevail? Anyways,
Your Lordship,
yes. I think you didn't get the question. Anyways, time up. Next.
It was a pleasure arguing before the bench, Your Lordship.
Good afternoon. Council seek permission to address the oral submission, Lordship.
Yes, please.
So this is council number 2 of Team K, and I would like to raise the two issues. The issue number 2 and issue number 4, that is the decision by states to make vaccine mandatory for various activities and provision of services is not legitimate, and whether the teacher in Kaya can legitimately refuse to be administered with the vaccine on constitutional grounds. So I would like to begin with the saying that restricting anyone from participating in an activity or service on the basis of merely vaccinated or not, it itself a violation of their fundamental right.
So council, how is it? Please cite some case. We don't need your opinion. How is it a violation of fundamental right by restricting someone on the basis of not taking vaccine? So please cite some judgment. At all you have cited any.
Okay. Lordship, I want to cite a case, not a case, but I want to refer to Article 16(1) of the Constitution.
All right.
In which that states that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Absolutely. So treating and generating opportunities for someone differently is itself a violation of Article 16 Clause 1.
No, I think you are trying to oversimplify it. It's not the correct interpretation. in my opinion. State has the power in the larger interest of people. See, why do you think the state wants people to get vaccinated, especially the government employees? Why do you think so? Because it's for the larger interest. They have to interact with the public at large. In this case, this teacher, this gentleman is a teacher. He has to interact with the students. Now, on his part, I mean, he may be well within his rights to refuse to be administered the vaccine, but government is also well within its rights to impose some disqualifications on this person. All right, you don't take the vaccine. Nobody can force you and, forcibly inject you the vaccine. That's fine. But there can be some disqualifications attached to it. Why not?
It was a case in Cruzen versus Director. It was a US judgment. It was a first right to die case that was heard by the court. And it was acceptable to require a clear and convincing evidence of a patient wishes for removal of life support. So I want to mention that in this.
Yes, we have some cases on the same lines in India as well, where passive euthanasia has been permitted. That's fine. But how do you apply them to this situation?
Because Lordship here, the teacher working in the state of Kaya can refuse because it is a violation of right to Article 21, that is right to life and personal liberty. And it was justified in the case of, I want to refer the case that Registrar General in versus State of Meghalaya 2021, which the court was of the view that the right of life guaranteed under Article 21 of the Constitution covers right to health, that is, person is at liberty to undertake a medical treatment or not as per his wish. And vaccination was the need of hour, but not a necessity. There has to be a balance between.
You're not getting it. That's fine. We understand medical necessity. You can refuse, but as a government employee, you are subject to certain regulations. Please understand. This is a case of a government teacher. This is not case of a common man. So there is a difference. When you are a government employee, you are subject to certain regulations. You can't say that I have all the rights under Article 21. Of course you have, but here the issue is government wants a particular class of people to be vaccinated. Now, this gentleman says, I don't want to get vaccinated due to XYZ reasons. That's fine. And nobody can force him. But there can be some disqualifications attached to it. If you don't get vaccinated, you can't come to school. You can't join services. That's fine. We have such restrictions in many services of the union. Like if you can't join armed forces if you are married. You can't join armed forces if you have a tattoo on your body. Now, you can't say that it is arbitrary. I have the right to have a tattoo made on my body and you can't disqualify me on this ground from taking up a service. These are reasonable restrictions. They have some nexus. So in this case, the rational nexus of this condition is it's the larger public interest. You see how this virus is contagious and this gentleman refusing it. And he has to deal with students as a teacher. So we can't put a lot of people just because of his beliefs at risk that he doesn't want to administer the vaccine. Let him not administer it. He can sit at home. He doesn't need to come to the office.
Lordship, if you permit me, I would like to answer this. Lordship, there is a reasonable nexus between the objective sought and the restriction made, but there is not intelligible differentia. But the reason of differencing, the basis of differencing, because other services also are also should be on a mandate of vaccination. There the difference made is on particular group, and within a state there cannot be a distinguishment between a particular group. Like particular state of Kaya here mentioned, the teacher was denied to administer with the vaccine and they imposed restrictions to attend the school. So it should it is for large interest, but there are also other services like post and telecommunication services or the grocery or shopkeepers.
Council, please understand, we can't go into that. It's a policy decision of the state. You are challenging it on the grounds of Article 19, 14 and 21. Please tell us, how does it violate these articles? Simple.
And I think I'm slightly confused on your line of argument, Council. What you are trying to say that it is illegitimate because it is it has been made mandatory. The vaccination issue has been made mandatory, right? So what I'm trying to, could you please make it more clear to me? Now what you are trying to the fellow judge that it is bad because the vaccination is bad. Making it mandatory is bad because it is for a particular class of servicemen. That's what you're trying to say. Because,
Yes.
because that is missing in your memorial. You are saying it is illegitimate because it is mandatory. Right? So, and I think if you are going to argue like that, then it is a flawed line of argument, because if somebody is saying that, no, don't go for teachers and go for this particular thing, then of course it would be illegitimate. But what I'm trying to say that your line of argument is something like that. I mean, this is what I found out, right? That
Pardon me, Lordship.
Vaccine mandatory for various activities and provision for services is illegitimate. That's what you've written. I mean, this is what you have written on page number 25, right?
Yes.
So what is your line of argument? Be clear, that to crystal, right?
Lordship, I want to comment here that the services on which the vaccine is mandatory is not legitimate, because the other services keeps the equal importance in a state, within a state.
That's right. Then you can make your prayer saying that it should be mandatory for all services, rather than saying that it shouldn't be made mandatory. If this is your line of argument, you can pray, let it be made mandatory for all services. We can do that.
I would like to refer to page number 26. I have mentioned that the difference made is class within a class. There is a differentiation.
No, we understand your arguments. I don't think so you are able to apply them to the facts of the case.
See, the thing is that what you're trying to say that the teacher was suspended because they make it mandatory, right? And and that's why it is illegitimate. But what I'm trying to ask is that there are certain protocols which you need to follow if you want to enter into a government service, right? Like the fellow just said that you don't have a tattoo or something like that. That's why, I mean, if you enter into as a teacher also, I can give you a certain example. If you work in a government sector, I'm sure Jamia Hamdard is not a perfect example because it's not a government institution. But if you want to enter into Delhi University, then of course you, for example, if you're a Muslim professor, you cannot marry twice, right? Though personal law allows it, but you cannot marry twice. You should not have a criminal record, right? So these are the things which you need to understand. I mean, you should not have a criminal record anywhere. But of course, what I'm trying to tell you that, I mean, a Muslim man can marry twice, right? But when it comes to the government services, it is not allowed. Whoever you are, whatever your faith is. So this is something. So it is a reasonable classification. It is a reasonable restriction which has been put out on everybody. So why? So if you are challenging this, then again I would say that you are challenging the entire jurisprudence, right? That do not make it mandatory on this particular class. So that's why I'm saying that what is your line of argument? Because if you are saying that it is mandatory because it is being made, it is illegitimate because it is being made mandatory, then it is good. But if you are saying that it is being mandatory to a particular class, then it would, open the Pandora box. Are you getting my point? So please just make it clear, because I'm unable to understand. Maybe my fellow judge will explain me what.
Pardon me, Lordship. I'm trying to prove the unreasonability of the differentiation made by government. That was my point.
No, counsel, we understand that, what you are trying to do, but it's not applicable. My brother judge has already explained. I have also been telling you, there are some restrictions when you belong. See, you are a government employee in the first place. You're not a common man. Government didn't pass this order that every person will have to be mandatorily administered the vaccine and he will suffer some disqualification. It is for teachers. Now, teachers is an identifiable class. There are some restrictions. My brother just pointed out that if you are a government employee of a particular university, you have certain restrictions. Now, that person who's applying for employment in that particular institution, he can't say either you challenge those clauses, challenge those restrictions. But here we cannot find any, it's not violative of any article.
Pardon me, Lordship, but the facts are silent on the point that
No, that's right.
Government.
That's I was asking you, is there some judgment? Because we understand there are many judgments from different high courts regarding compulsory administration of vaccines, but we can't find any in your memorial. There are recent judgments which various high courts have passed. In fact, there was a recent judgment from Kerala High Court we had on the same issue, wherein they said that, yes, it cannot be made mandatory, but there can be disqualifications on the basis of, voluntarily not taking the vaccine. In fact, recently in the third wave of this virus, some state governments said that people who have not voluntarily taken vaccines, we won't give them treatment in government hospitals. So that is also one of, I mean, such orders have not been challenged yet before the court, but they have said that people who had the opportunity and they have not taken vaccine, if they suffer this virus, we won't give them government treatment in government hospitals. So please cite some judgment if you have any.
Pardon me, Lordship, for this, I have judgment on page number 42.
All right.
It is, I mentioned, page 42, para 11.
Yes.
May I read that?
Yes, we can see that in the present case, you are reading state government made
Vaccine mandatory for office staff, teachers, and audience in cinema halls in order to check the spread of virus.
Yeah, you're cited as 167, Moot proposition para 6. All right.
Yes.
All right. What else?
Orders denying people their livelihood in relation vaccine status would be illegal on part of the state, if not unconstitutional.
All right.
And the respondent may submit that state government is reasonable. It is therefore the petition must submit that as per the division of power provided under Article 246, public health is a term under state list, as in the Constituent Assembly.
But what are you trying to argue? This is an argument from the respondent side. You are for the petitioner. I mean,
no. I mentioned that if respondent argues this way, the petitioner have the point to say this.
All right.
May I proceed with my further arguments, Lordship?
Please conclude.
Okay, thank you. So I want to raise issue on that the said regulation violates right to informed consent, which right to informed consent is a fundamental right. And Honorable Supreme Court had established previously that informed consent by a patient is prerequisite need, even in medical procedure, in the absence of which such no procedure can be undertaken. And it was mentioned in Samira Kohli versus Dr. Prabha Manchanda, 2008.
All right.
And should I state the facts of the case?
No, that's fine. See, we understand. Let him not take the vaccine and quit the job. As simple as that. You want to have the cake and eat it too. It's like the same situation.
But
quit
in Article 19, citizen have right to.
So has the government to impose certain restrictions. Once you take up employment in a government institution, government body, government department, you are subject to certain regulations from time to time which the government passes. So this is a reasonable, this condition which the government has passed that teachers should get vaccinated.
But
now,
Lordship,
I don't want to get.
But Lordship, in the Moot proposition, it is not mentioned that whether school is private or government. That's why I raised that issue.
That's fine. I mean, we can assume that. Anyway, what else do you have to say on the migrant crisis? Another issue you have?
Yes, I have another issue that the teacher in Kaya can legitimately refuse to be administered with the vaccine on constitutional grounds.
That's fine, but in the first place, you will have to satisfy us. This teacher is not before us. You are espousing his cause in a PIL. Can this be done in a PIL? You are taking an individual's case by way of a PIL. This person has not approached us. He can approach us if he is aggrieved.
Yes.
How can you espouse his cause by way of a PIL? Please tell us that.
In the alarm of public interest?
No, that's fine. This is an individual case. This is not a case of hundreds or thousands of teachers. Even if it was so, they could have.
There are similar cases reported also mentioned in Moot proposition.
Oh, that's fine. We can understand in case of migrants. I mean, they are people from lowest strata of the society and they don't have means to maybe hire lawyers or to approach the highest court. That's fine. We can understand taking up their issue in PIL. But yeah, issue of a teacher, if he is aggrieved, he can approach the High Court concerned in the first place.
I would like to mention para number 7 of the Moot proposition, Lordship. It mentions that, I am reading it. May I?
Yes.
It is a teacher working in one of the schools in Kaya did not want to take the vaccination due to his beliefs. Due to his reluctance of not taking the vaccine, the school suspended him. Moreover, many reports of people being denied to enter their workplaces and movie halls start to emerge. Similar incidents were reported in other states of the country and the same gained widespread attention. So the NGO Right to People is filing a PIL under Article 32 of the Constitution on behalf of this.
All right. Please proceed further. What else do you have to say on this?
Yes. I would like to say that it is mentioned in Indian Medical Council Regulation 2002, which provide for informed consent of the patient for various medical procedures as well. Here in the in the procedure of vaccine, the efficiency of vaccine was not mentioned anywhere, as the trials, human trials were not there, as vaccination, as the first case of COVID-19
I don't think so.
came.
You're getting our point. We are not saying he'll be forcibly picked up and he'll be forcibly injected the vaccine. Let him not take the vaccine. Nobody is saying government order. The school doesn't say you have to mandatorily take the vaccine. But see, if you are in your college or Dr. Farooqi is working somewhere in his workplace, if the workplace brings an order that you can only enter, you can only come to the workplace if you have taken vaccine. So what is the harm in that?
But here services have been terminated, Lordship.
They have to be, because he's not complying. They have to be.
But there are people, like there are various side effects of the vaccine, Lordship.
What are the side effects? Please tell us. Please tell us what are the
side effects. Like I haven't mentioned in my memorial, but
you have to. How else do you say that I won't take the vaccine?
No, it's in regard to WHO reports, because the Moot proposition is prime.
Fine. Are we bound by WHO reports? Please tell us. Are we bound by such reports?
They are just suggestions, and
that's right. But you are trying to create a separate class for yourself. We are fine with it, but then you can't be in service. That's our opinion. Anyway, what else do you have to say on this?
Okay, Lordship, I want to say that like people who are there, it's an extra P1 circular. It was mentioned that the people who cannot take vaccine have also the permission to enter into institutions and hostel by providing a medical certificate of the reasons why they can't get vaccination, as the people with heart problem or valve replacement cannot take vaccine because vaccination will cause the stroke and blockage of
but here, that is not the case with this gentleman who has been suspended. We can understand in their cases people who suffer from some comorbidities, they are not taking it on the strength of some medical opinion that if they take vaccines, there can be some elevation of their medical condition. That's fine. But otherwise, a common man denying it on his beliefs, if we start respecting everyone's beliefs, that too at the touchstone of the constitution, I don't think so. Then it will be,
I want to point one thing that
for the government to run the country. Anyway, yes.
In the said regulation, unfair intrusion into the bodily integrity of an individual is being done by denying them the autonomy to permit such access to their body. They have been restricted to do certain profession and to be permitted in their occupation. And states and UTs are mandating injections, the safety of which has neither been displayed nor guaranteed. And it was there in Moot proposition also that there was a great reluctance regarding the vaccination. And I would like to mention
yes,
the said regulation is not in the accordance with the principle of Article 14, that is equality before law. As it is mentioned in my memorial also, that the Constitution of Selexa and being a subordinate legislation it violates Article 14 because it is a legislation made by an authority subordinate to legislature. And I would like to say that if this cannot be a proven first impression on the surrounding circumstances, and the legislation is supposed to struck down because it's considered as a naked discrimination because the class within the class is made here. And I would like to raise that the Epidemic Disease Act gives power to take temporary measures to ensure the prevention of the spread. However, the vaccination is a permanent step which have long-lasting side effects also, which has been globally studied. And I would also like to say that vaccination, the trials of vaccination, as the first case of COVID-19 in Selexa come on 1st January 2020, and the vaccination came on 16th January 2021. So it is just a 1 year, and there were no human trials. How can you say how can you justify the efficacy of vaccine on that basis? Because there should be in the report of WHO, there should be the 3 phases 1, 2, 3 phase of human trials, because different bodies of different age groups will react differently to the vaccine.
That's right. But Council, I don't think so. We are competent to assess that. We are not experts.
No, we are not expert, but it was the urgent need, but it was not a necessity to make the vaccination mandatory.
You have appropriate remedies. You can make representation to the concerned authorities. How can court decide this?
Pardon me, Lordship.
Anyway, what else do you have to say? You have only 1 minute left.
Yes.
In the chat box. You can please come to the prayer.
Should I conclude and after that should say the prayer, or?
Yes, you just have 1 minute. Whatever you want.
Okay. Wherefore, in the light of facts, adduced issues raised in argument in advance and authorities, it is humbly and respectfully prayed to the Honorable Court may be pleased to adjudge and declare that the writ petition by way of PIL is maintainable under Article 32 of the Constitution of Selexa. Secondly, to issue a writ of mandamus or any other appropriate writ declaring that state decision to make vaccination mandatory for.
So would it be mandamus or any other writ? Which writ would it be? Please tell us the appropriate writ which we should issue to declare this mandatory provision as illegitimate.
It's mandamus.
We don't think so. It's mandamus. It won't be mandamus. What is the third prayer?
To issue a writ of mandamus or any other appropriate.
I don't think so. Again, it would be mandamus. It won't be mandamus.
And to allow the teacher in Kaya to refuse to take administered with the vaccine on constitutional grounds.
All right. I don't think so. These anyway.
Or certiorari if it deems fit.
Yes, it has to be certiorari, right? We can't quash an order by way of a mandamus. Anyway.
Pardon me, Lordship. Yes. It's certiorari. So I want to conclude it.
All right.
Thank you, Lordship.
Thank you. Courtmaster, we'll take a minute to mark. Then we start with the next team, sir. Would that be appropriate, Dr. Farooqi and Mr. Kaul?
Okay, I think we can start with the other team, I guess. What is the rule? I mean, is there any procedure?
Not really. I mean, since we have to mark them as speaker 1 and 2, we have to mark speakers separately. Then it might be a little confusing since we'll be hearing 2 more speakers, then to mark them individually. That's all. Otherwise, we can mark them later.
No, I think I already did that. I think you
very well. Yeah, very well. No issues, sir. Then we can proceed with the next team. I think it's team G, the respondents.
Yes, Your Lordship. May I proceed?
Yes.
Greetings to the Honorable Bench. Council solicits permission to begin with the issues.
Yes, you are speaker number 1.
Yes, Your Lordship.
Yes.
If the court is well versed with the facts and jurisdiction of the case, may I proceed?
Tell us facts briefly in a minute.
Yes, Your Lordship. WHO announced a lockdown on April, and after that, WHO announced the COVID-19 as a pandemic in April, and after that, Union of Selexa announced lockdown on 24th March 2020. And
the lockdown was imposed, then WHO declared it.
Your Lordship, in April.
Yes, WHO declared it as pandemic, and in.
What happened in April?
On 30 January 2020, in a city of Wuhan, China, where the first case was reported of COVID-19. After that, gradually.
I don't think so. It was 30th of January 2020. I don't think so. That's the correct date. Anyway.
Yes, Your Lordship.
2019.
It's 29. Pardon, Your Lordship.
Yes, please proceed.
Your Lordship, on 25th March, amateur order came, and with that, lockdown was imposed. And petitioner, rights of people, has approached the court for the violation of the fundamental rights.
All right. So you are preparing for the union.
Yes, Your Lordship.
Yes, please come to your issues.
I'm dealing with first and fourth issue. To answer this particular issue, I will be making 3 submissions before the Honorable Court. Firstly, the present PIL is not maintainable. Secondly, the present PIL has been prematurely filed. And
at last I will whether this honorable court would be justified in interfering in the policy decision of the government. I would come to my first submission that the present PIL is not maintainable because according to the Constitution of Selexa, public interest litigation can be only filed under Article 32 when there is a violation of fundamental rights. But in the present case, there has been only reasonable restriction imposed on such fundamental rights by the Union of Selexa. Since the action taken by the state was in furtherance to protect the public health interest, the council would like to refer to the page number 13 of the memorial, where there is mentioned a case of association and drugs, pharmaceutical manufacturer AP versus AP Health Medical Housing and Infrastructure Development Corporation.
Yes, this is a Supreme Court judgment you are citing?
Yes, Your Lordship.
All right.
Your Lordship, in this particular case, the court held that the petition cannot be maintainable if its sole purpose is to question a policy decision of the government. In the current matter also, the petitioner filed this PIL mainly questioning the policies of the government. Hence, it cannot be maintainable because the respondent has made those decisions to protect the public health interest at large.
So how are you protecting the public health interest? How are you protecting?
Your Lordship, by putting some reasonable restriction that is required.
But we don't think so they were reasonable. You imposed lockdown all of a sudden without providing window to the people who, literally stay on the roads. They had nowhere to go. How was it?
Your Lordship, the pandemic was unprecedented.
Well, that's right, but you could have given them some window, organized special trains or buses for them so that they could have reached their homes.
Your Lordship, we have organized many things. We have organized Shramik trains that was more than 4,000. We have given one nation, one ration.
Where do you say it from? Where do you say it from?
Your Lordship, I would like to refer to the memorial.
Yes. No, not memorial. You tell us from the facts. This is not what the facts say you have done so. This is what you have just added and assumed that you have done it.
Your Lordship, as written in the Moot proposition that facts and laws are pari materia to the Constitution.
That's right, but you can, of course, you can rely on laws, but you can't make your own facts. That's not what the facts say, that you had organized some trains or whatever you are citing as.
Your Lordship, pardon, Your Lordship, it was written that facts are also pari materia to the Constitution.
Oh, that's right.
The situation of India.
Yes, but that is not in the facts that you have done so.
Yes, Your Lordship, we have provided.
It only says the laws of Selexa, laws of India are pari materia, not the facts. It's just the laws. Facts are, you have to stick to the Moot proposition. You can't go beyond it.
Pardon, Your Lordship.
I'm saying you have to stick to the facts in the Moot proposition. You can't import your facts. Yes.
Indeed, Your Lordship.
Yes.
The council would point out that the case of state of MP and others versus Nandilal Jaiswal and others, where the court observed that unless there is a prima facie evidence to prove the exercise of discretion being arbitrary, unreasonable, or malified, the court cannot step into the issues of the government to decide the validity of a policy. Thus, the respondents humbly submit that the present petition is not maintainable on the ground that it has the decision made by the state were according to the situation and were necessary to tackle the unprecedented situation. The council would like to refer to the the Moot proposition, where it was mentioned on 30 January 2020. Selexa reported its first case, and slowly and gradually by April 2020, the number of the cases drastically risen to 5,500 infections and 150 deaths. Your Lordship, in March 2020, WHO declared COVID-19 as pandemic, and the scale and severity of the COVID-19 pandemic was clearly rose to the level of the threat and the threat against the public health. And since there was
January, we had first case in January. Is that right? So what were you doing since January? You didn't impose any restrictions for the flights coming from outside the country. Now suddenly in the March you wake up and impose restrictions all of a sudden, and everyone is taken by surprise, and we have lakhs of people on roads.
Indeed, Your Lordship, but we have taken the measure as sudden lockdown was necessary because we wanted to stop the movement of the people. So,
but it didn't stop. You failed to achieve that. It didn't stop the movement of people.
Your Lordship, it was necessary, there's a doctrine.
Yes, what is the doctrine?
Your Lordship, I would like to refer to the case.
Which case?
Bandha Mukti Morcha also Union of India 19.
You're also referring to it. The petitioners also refer to this. What are you trying to say by relying on this?
Your Lordship, it is in this particular case, the court held that creation and sustaining of condition that is congenial to good health is a responsibility of the government.
Indeed.
So that's what responsibility state was trying to achieve.
Correct. But how did you achieve that? How did you exercise such responsibility?
Your Lordship,
Putting people on roads.
Your Lordship, government has taken many measures to curb the to deal with that migrant exodus.
Yes, what have you done?
We have conducted Shramik trains. It was more than 4,000 Shramik trains. We have organized cooked meals. We have given free rations to the migrants who were going back to their homes. And
I don't think so. I think this is just on paper. We have a different picture before us.
Your Lordship, for the larger public interest, we have to announce a lockdown on a sudden because the virus.
I understand that, but the crisis it led to, how do you justify that? That's what the PIL is about.
Yes, Your Lordship.
See, the government decisions can't be knee-jerk. You have to have a vision when you impose such a, it was unprecedented, such a lockdown in the whole country. You should have predicted that it would result in, hardships to a large number of people in the society who literally stay on roads, who have nowhere to go, who are daily wagers. So, I mean, you had no mechanism in place.
Your Lordship, according to the Moot proposition, Selecza is the seventh largest economy of the world.
That's right.
If we impose a lockdown earlier, the economy will be drastically goes down. So
now you're confusing two things: whether you want to promote economy, you want to save economy, or you want to save the people in the first place.
Your Lordship, the Union of Selecza is maintaining both the things to maintain a public health at large and maintaining economy as well.
If it leads to death of people.
Yes, Your Lordship, but if the lockdown was not imposed, it would be great. It would cause greater harm to the public at large.
All right. What else?
More people will be died.
All right. What else?
Your Lordship, I would like to turn to the submission too, that the Article 47 directs the state to raise the level of the nutrition and standard of the living, and respondent has also the similar legitimate aim to protect the public health. The right to health has been held under Article 21 of the Constitution.
The first issue we understand was this PIL is not maintainable. So now this is which issue you are dealing it with?
Your Lordship, it is for issue number 1.
All right.
So it was not arbitrary. Right to health has been under Article 21 of the Constitution of Selecza and imposing an obligation on the state to maintain and improve public health.
All right.
Also under Epidemic Disease Act, the state can take whatever measure necessary to prevent the spread of an epidemic disease. Section 6 of the Disaster Management Act gives power to National Disaster Management Authority to formulate any policy to tackle disaster. Along with Section 35 and 36 of the Act provides Union government to certain powers to take necessary measures concerning disaster management. This includes issuing guidelines to the state and government and non-government organizations about tackling the disaster.
All right.
Your Lordship, I would like to turn to the third submission, that whether the Honorable Court would be justified interfering with the policy decision of the government.
Yes.
The respondent most humbly submits that the Supreme Court has held that the interference into policy action is not within its jurisdiction. The council seeks the attention of the bench.
Yes.
Your Lordship, in the case of Directorate of Film Festival versus Gaurav Ashwin Jain and ORS 2007.
Where is it?
Your Lordship, I'll tell you.
Which page of your memorial, please?
Yes, Your Lordship. Your Lordship, I will be failed to.
All right, please tell us what happened in this case.
Yes, Your Lordship, much obliged.
I want the researcher to answer the question, which my fellow judge asked.
Your Lordship, it has been mentioned on page number 12 of the memorial.
Okay.
All right, what does this case say?
This case, the court held that in this particular case that court should not rush and where even scientists and medical experts are careful to take steps. The rule of prudence is applied and the courts will be reluctant to interfere with policy decision taken by the government in matter of public health, even after collecting or analyzing inputs from surveys and research.
All right.
Your Lordship, in the present case, the respondent make decision after WHO declared the pandemic in March 2020 that COVID-19 is a deadly virus and every country should take lockdown measure at a certain point.
No, that's not right. Opposition, if we understand, there were some voices in the opposition which were asking for imposition of certain restrictions as early as in January. But that time you didn't pay any attention to, such voices. Now, what we are concerned with, why it was so sudden. You could have given them a window of at least a week so that people would have traveled to their native places and then we wouldn't have so many people on roads.
See, I would like to improvise the question. What I would like to say is, you say that for the economic betterment of the country, you delayed the imposition of the lockdown, and this was hence brought in March, right? Now, during these 2 months of Jan and February, you could have given the window to all these migrant workers to go back home. They could have done this on their own. No need to provide any trains or any commutation whatsoever. You could have just given an intimation.
Indeed, Your Lordship, I would clarify that the sudden lockdown measure was taken only to stop the movement of the people, to stop the virus, because the virus was very contagious and it is.
Right, Counsel, you have said so earlier as well. We understand that. Issue is, did it actually stop the movement of the people?
Your Lordship, it has stopped the movement of the people, but the
Nobody was traveling on road then. That's what you're saying. Nobody traveled after you imposed restrictions. Who were on roads?
Migrants were traveling, but the migrant exodus was unpredictable and unprecedented situation that occurred, and the government earlier have no choice. This virus has the number of virus has risen so drastically that the government have no time to think about the future consequences.
When you compensate them, if you couldn't predict it, then you are admitting that government failed to predict the result of your certain lockdown, the consequences of the lockdown. Then why don't you compensate them? If it's a failure on your part, as my brother just suggested, since January, February, you could have given them the window. You could have said that we are going to impose some restrictions from March. So please take measures accordingly. Now, if you have failed to do so, if you have failed to predict that this would lead to such hardships, you should be, imposed with some cost, and you should compensate people who have suffered.
What
do you have to say about it?
It means you're accepting that it was not a planned decision, right? It was not a planned order.
Yes, Your Lordship. It was a planned lockdown. No, Your Lordship.
No?
No.
Yes. Earlier you said this was done for the economic betterment of the country.
Yes, Your Lordship.
So what are you trying to say?
It was not imposed earlier because of the economic betterment of the country, but at a certain time when the virus was the number of virus spread really fast, so government has no choice but to impose the lockdown.
Do you have any data or a report which suggests that it will bring an economic boost?
Your Lordship, it was not arbitrary to impose a lockdown.
Well, my question is different, Counsel. You are addressing a different issue on another level. What I'm trying to ask that, do you have any data which compelled the government to take that kind of a decision?
Your Lordship, the suggestion of the WHO also cleared that at the end of
the WHO, did WHO tell the government to impose the lockdown? Or
no,
even if the WHO would tell, then WHO decision or the suggestion is obligatory?
No, Your Lordship.
Then
It was, Your Lordship, taken for the public health interest. To
That's right.
maintain
But did it achieve that? All we are trying, we understand
certain
that
point,
there were noble, reasons for you to bring such orders. But did it help?
at a certain point, it achieved to maintain the public health, because if we don't impose the lockdown, the consequences will be far more grave. It will be more higher than 30%.
All right.
Do you have a data to prove this point that it will be higher than 30%?
Your Lordship, I have not mentioned that in the memorial.
Then why are you saying it? Why are you talking in the air?
Pardon, Your Lordship.
Please proceed.
Your Lordship, now the council is moving to the fourth issue, that is whether the teacher in Kaya can legitimately refuse to be administered with the vaccine on constitutional grounds. To answer this particular issue, Your Lordship, I will be making 3 key submissions before the Honorable Court. Firstly, right to health is an integral part of right to life. Secondly, states' right to regulate the behavior of an individual when it negatively impacts the society. And lastly, right to privacy is not an absolute right. Your Lordship, the Council would like to turn to the first submission, that right to health is an integral part of right to life. The current situation responded is aiming to maintain condition that is congenial to good health by vaccinating all the people of the country. And Your Lordship, denying the unvaccinated people to transmit the virus to others. The Council would like to refer to the page number 21 of the memorial. There's a case mentioned, Consumer Education and Research Center versus Union of India, 1995. Your Lordship, in this particular case, a Supreme Court held that right to health is a fundamental right, and it is an integral part of right to life under Article 21 of the.
Nobody is disputing that.
So the states have mandated the vaccine.
Even petitioners are not disputing that right to health is not a fundamental right. It is. What are you trying to say?
With respect to safeguarding public health, with respect to safeguard the public health, the state was bound to vaccinate its people, and we have not mandated the vaccine at all.
Yes.
As it is mentioned in the website of Ministry of Home Affairs, that vaccines are completely voluntary.
Home Affairs or Ministry of Health website? Which website are you referring to?
Ministry of Family and Health.
Yes, not Home Affairs. Yes. What does it say?
It says that in the frequently asked question that vaccines are completely voluntary.
Correct. But how do you disqualify this person? How do you suspend this person? How do you justify suspension then when they are voluntary?
Your Lordship,
if it is voluntary, there can't be some disqualifications attached.
It is voluntary, but it is suggested.
Suggestive only, that's right. But how can you suspend this person?
Your Lordship, unvaccinated people can spread the virus.
Then it's not voluntary.
We cannot allow the unvaccinated people to transmit.
That's right, but then it becomes mandatory.
It's not mandatory, but it is a reasonable restriction to the people.
No, then it becomes mandatory for such people. In other words.
Yes, Your Lordship, it's not a direct mandatory, but it's indirectly leading to
what we call as tolerable exercise of power.
Yes,
what
Your
you
Lordship.
do directly, you are doing indirectly. You are saying on one hand that it's not mandatory, it's not compulsory, but people who don't get vaccinated, they'll be suspended from their services. What does that mean?
Because Your Lordship, to deal with the larger public health interest.
Yes, that's right. Then you make it mandatory. Why are you shying away from saying that it's mandatory?
If the government have mandated the vaccination, then it will be a violation of the bodily integrity.
But
here,
for this person.
But here, Your Lordship, in the present case, people have the right to choice about their
they don't have
vaccine. But yes,
so he has choice either to choose the vaccine or to choose the job. Is that what you're trying to say?
Indeed, Your Lordship.
So then it becomes mandatory.
It is mandatory for a particular service and public.
Okay, so hold on. So you're trying to say that for certain class of servicemen, for a particular category, I mean, for a particular category doesn't have a right to health. Is this what you're trying to say? Because no, just listen to me. Because what you're trying to say, initially you try to draw an analogy, right? That in order to protect the public health, you can, you can actually, and to protect the public health, you can cost the privacy of people, right? This is what you tried to say. Are you getting my point? So what I have understood from your argument, that a particular class of category can be vaccinated, right? Because they are doing a job, right? They want to, they want to make their livelihood. So what I'm trying to say, what I'm trying to ask, that so they can be, it can make it mandatory, it can, they can be forced to take the vaccine, because, and in the result of it, they should not have any, their right to health, because you don't have a proof, you don't have a trial, you don't have, it was not tested properly, you don't have a good result about their efficacy of the vaccine. So you are costing their health, right? So your health argument is flawed, counsel. Are you getting my point?
Yes, Your Lordship, but the council contends that health arguments is not fraud, because
Why?
if one person is not taking the vaccine, the other person is exposed to the deadly virus.
Okay, so now it's a debate between individual right and a group
public
right?
Health rights.
No, a group right? So you are costing a life. So you can kill one person in order to save a life of other person, and you as a state need to protect all people. This is what you need to do.
Your Lordship, there's a data of a recent AFI committee which says the government has administered 119 crores of vaccines up till now, and only 0.01% have adverse effects.
Where is it mentioned? Where is mentioned? Show me the facts. Page
Adverse
number.
events, it is mentioned in the adverse events following immunization committee report, Ministry of Home and Family Welfare website.
Health and Family Welfare.
Yes, Your Lordship.
So, counsel, and as you are suggesting, you can't expose a number of people due to one person. There is no data to suggest globally that people who are vaccinated, that they can't lead to transmission. Transmission is still there. The consequences are less serious among people who are vaccinated, but transmission can still take place even if you are vaccinated. Vaccine doesn't prevent transmission.
That's what I did talk about, that you don't have a data to prove the efficacy. Can you say that vaccine is 100%? Can you say the protection is 100% from the vaccine? Does it protect you 100%? If you show me the data, then I will get you, we will give you the relief. The problem is that you don't have the data, right, to prove the efficacy.
Your Lordship, I have the data where 0.01% adverse effects can be seen.
I'm not talking about the adverse effect. I'm talking about the efficacy. Does it give you the protection?
Yes, sir. Yes,
against the virus.
At a
is it 100%?
No, Your Lordship. I would like to clarify that no vaccination is perfect. That is.
I think your time is up, Speaker One. We can see in the chat box.
Your Lordship, I want.
Yes, please conclude within 1 minute. Yes.
Yes, Your Lordship. Much obliged. Your Lordship, the Council would like to turn to the last submission that right to privacy is not an absolute right, because I would like to refer to page number 20 of the memorial.
Yes.
The government's action in making vaccination mandatory fall under their legitimate duty to protect the general public. Many medical health experts around the world.
No, you are saying that's right, but in the first place, you said that it is not mandatory. Your website shows, the Ministry of Health website shows it's not mandatory. Now, why are you trying to say that government trying to make it mandatory is justified? What are you trying to say? Is it mandatory or is it not mandatory?
It is mandatory for certain provision.
Right. Yes. What do you have to say on this? Please wrap up in 1 minute.
Yes, Your Lordship, I would like to refer to a case of Ritesh Sinha versus State of Uttar Pradesh, where it was observed that right to privacy or personal liberty must bow down to compelling public health interest. Similarly, in the present case, if the petitioner is arguing that right to privacy is a fundamental right, right to privacy have to go down to the compelling public health interest at large. Thus, the negative reinforcement it proposes aimed at is indeed a reasonable restriction to the aforementioned rights. Respondent is denying the unvaccinated people by all means to transmit the virus by using the license of right to privacy as a tool. If the lordships are satisfied with the arguments, I would like to proceed. I would like to call out my co-counsel.
Yes,
Proceed with the, yes, much obliged.
Greetings to the Honorable Bench. This is the Council 2 of Team G on behalf of the respondent. Council seeks permission to collectively call bench as your lordship.
Yes.
Much obliged, your lordship. Council will be dealing with two distinct issues, which are issue number 2 and issue number 3. Issue number 2 is whether the decision of state to mandate the vaccines for various activities or provision of services is legitimate. To deal with this particular issue, the council would like to make 3 submissions. Firstly, the impugned order is made as per the instructions of the central government. Secondly, the impugned order is passed in order to improve the public health. And thirdly, restrictions of the fundamental rights are reasonable restrictions here. The Lordship Council wants to make first submission that the impugned order is made as per the instructions of the central government. Under Section 6, Clause 2, Subclause D of Disaster Management Act of 2005, the National Disaster Management Authority has the responsibility for laying down the plans, policies, and guidelines to manage the disaster, and this also includes issuing guidelines to state governments and the non-governmental organizations. By following that, Your Lordship, the MHA due letter on 28th July of 2021, Your Lordship can refer to the page number 14 of the memorial. The MHA due letter on 28th July of 2021 was issued to all the chief secretaries and administrators of the states and districts with instruction that all the efforts should be made to ensure that there's no increase in the R factor. R factor is the reproduction number of the virus, and issues strict directions in the areas of states and districts that are still showing high positivity rates. And then again, MHA order on the 28th September of the 2021, which directs the states and the union territories that they can plan additional public health measures as deemed necessary based on their context and the situational analysis of their areas. On page 11 in the para 6 of the Moot proposition, it is mentioned that when after providing the data efficacy report to the people about the vaccine's efficacy, but people were still reluctant to taking the vaccine. Then their state, according to the guidelines of the national MHA order, plan the additional guidelines as per they have the power that the MHA ordered them.
What issue you are dealing with? What is the argument you're trying to make by citing these orders and letters?
I'm citing that state mandated the vaccines as they have the as per the instructions of the central government MHA orders.
All right.
Yes. So, Your Lordship, now Council wants to make second submission. For that, impugned order is passed in order to improve the public health. The Constitution
MHA order you are referring to, or
yes,
the mandatory vaccination?
Yes, Lordship.
No, which order are you referring to?
I'm referring to the MHA order which was passed on the 28th September of 2021. I mentioned it on the page number 14 of the memorial.
But it's not the fact. That's not what is mentioned in the facts. What does 28th September order has to do with this? See, we are concerned with maintainability of the PIL. We are concerned with making vaccines mandatory for services. We are concerned with MHA order regarding lockdown. What is to be done with this September 21 order?
Actually, under the Disaster Management Act of 6 Clause 2, the National Disaster Management Authority has the responsibility to lay plans and policies and direct the states to issue guidelines.
Yes,
and,
that's fine. Yes. What does this September order say?
It says that the state and union territories can plan additional public health measures as deemed necessary based on their context and situational analysis of their areas. That was the situation of the virus in their areas, they can plan according to that.
That's fine. Now, how do you justify this order?
I want to justify the order in that way, that that's why the state has mandated the vaccines, as they have the instructions and they have the consent of the central government. The
No,
state
but
cannot
your
make mandate.
your co-counsel just argued that they are not mandatory. Your website shows that they are voluntary. It is not mandatory. How do you say that it's mandatory?
Exactly what he has said. He said the FAQ section clearly points out that if somebody wants to go for it, he can. So the liberty is with the individual.
The further is written there, Your Lordship, that the vaccine is voluntary, but they recommended it that everyone must take it for their health.
That's fine. See,
two different.
You're not getting it. We are asking whether it's mandatory. Your co-counsel said, he said that our website, that is the Ministry of Health website, under FAQs, clearly mentions that these vaccines are voluntary. They are not mandatory. Now, at the same time, you are arguing that they are mandatory and you're trying to justify the mandatory nature.
They are on the FAQ website of MHA. It is written that they are voluntary, but yes, Your Lordship.
Yeah, I mean, what my fellow judge is saying is something different. I mean, what he's saying that your co-counsel has just said something different. So maybe you people have, I mean, not aligned on the same line, right? The line of argument is something different. I'm sad to see this, seriously. Why are you arguing like this? Maybe we have a 3-team now. The 3 teams are arguing on something very different, on a very different line of arguments.
Apologize, Your Lordship, but
yes, what do you have to say about it? We understand the government has the power, but how can you disqualify a person? Idea is, we understand the initiative is very noble. You want to protect the public health. Right to health is part of Article 21. We understand all that. That has been argued. But how do you justify the disqualifications to the people who don't take vaccines? How do you justify the suspension of this gentleman from the school? How do you justify denying admission in cinema halls and public places to people who have not taken vaccine?
Your Lordship, if you can refer on the page number 15 of the memorial.
Yes, we can refer. Please answer the question. Yes.
Yes, Your Lordship, I'm answering.
Yes.
That through some research paper, and it was found that other communicable infections like measles and diphtheria and polio have demonstrated the herd protection. And just like that, in this COVID-19 virus, this is also a highly transmissible infection. And the state ordered to mandate this vaccine in order to create the herd protection. So the vulnerable section of the society, like the people who have some medical issues and due to which they cannot take the vaccine. So by creating the herd protection in the state and in the country, the government can protect those people who are not eligible or in any way they cannot take the vaccine. That's why the state took the action of mandating the vaccines, and even the state have provided the first efficacy, or according to Moot provision, they firstly provided the efficacy report on the vaccination.
All right. So we understand that. All right, we'll assume that you have made it mandatory, even though your co-counsel said something else. Let's assume that this vaccine is mandatory. Now, how do you justify that people who cannot see, there are judgments to the contrary, which say that, anything related to a person's health and bodily integrity, you cannot, it's part of fundamental right. A person can refuse a particular line of medical treatment even. So how do you justify this?
If the people have, the people who are able or eligible to take the vaccine, who do not have any problems, they have to take the vaccine. They have to think about other people also in the society who are not any way able to take the vaccine.
My brother judge, Dr. Farooqi, also asked earlier to your co-counsel that do you have any data to suggest that people who have taken vaccine, that they are immune from getting infected? We understand there is data to suggest that people who have taken vaccine if they get infected, there will be less serious consequences among them. We understand that. But do you have data to suggest that once we take vaccines, then we are immune from getting this virus? If that is the case, then we can consider this relief. We can consider making it mandatory and upholding your order. Otherwise, if you don't have any data, and in fact, we have studies and data before us which suggest that it doesn't stop transmission, but yes, consequences are less serious once we take vaccines, but it doesn't stop transmission. So do you have any such data regarding efficacy?
Your Lordship, Your Lordship, we have to stick to the Moot proposition, and according to that, we on para 6, it was written that they have provided the vaccination efficacy report, and we cannot refer to any other data.
All right. What else do you say? What else?
And according to the
regarding vaccination, any recent judgment? I asked the other side as well. There are many judgments from various high courts regarding vaccination. Do you have any recent judgment?
If I refer to the recent judgment of the pardon me, Lordship, I don't have.
You have referred to judgments from 70s, 80s, 60s even. So there are many judgments on this Moot proposition we are having.
Yes, Your Lordship.
Any judgment regarding compulsory nature of vaccines and justification regarding the same?
There was one international case, one and only case in which the vaccines were mandated. It was a Jacobson versus Massachusetts case, which was on the page.
Have you cited it? Where have you cited it in your memorial?
Yes, Lordship. I have cited in the memorial on the page number 16 at the top, in which the US Supreme Court held that in order to protect the public health, we are contending the individual.
It's a 1905 case you are referring to. It's pertaining to year 1905?
1905, yes.
Yes, Your Lordship.
I think that is taking it a little too far. Yes. Anyway, what did this case say?
In this case, is the Supreme Court held that in the public health regard, we cannot take the individual's right into the consideration of
the century-old case you are citing. I'm sure the jurisprudence has developed on this issue a lot in the past 1 century. You could have cited some latest case to back your argument rather than going back to 1905.
Your Lordship, this is the only case which I got on mandating the vaccine and
Republic of Select. You have no case.
Your Lordship, on this, I wanted to say that whether it is a past century ago or it is this current century, the main motive of the the government is to protect the public health.
Yes. What else?
Your Lordship, with this, I wanted to make my next submission that that impugned order is passed in order to improve the public health. The Constitution of Selexa directs the state to improve and protect the public health of citizens under the Article 47 of the Directive Principles of State Policy. And Your Lordship, on page 13 of the memorial, in Vincent Panikurlangara versus Union of India and others, 1987, AIR 1990, Supreme Court report para 2, page number 68. It was held that a healthy body is the very foundation of all human activities in the welfare state. The maintenance and improvement of public health have to mark high among the state's obligation, as these are very essential for the existence of the community. And in Vebrica and others versus the Czech Republic case, which was the recent case of 2021, the court held in this case that country.
This case, counsel, please.
Yes, Lord. Yes, Your Lordship. This case has been cited in the page number 15 of the Moot memorial.
Yes, which footnote?
Footnote
or the paragraph?
26, Your Lordship.
Footnote 26.
Yes,
all right. What does this case, I got it. What does this case say?
This case said that the country's government is under an obligation to protect the life, and if mandatory policy of vaccination was the means to achieve herd immunity, they were very well within their power to do so. And under Article 21 on right to health, the state have an obligation to protect the and improve the public health.
All right.
With that, Your Lordship, Council wants to make final summation that the restriction on fundamental rights are reasonable. The petitioner has been implying that by mandating the vaccines for various activities and provision of services, that's the violation of the fundamental rights of people under Article 19, Clause 1, Subclause G, which is the right to practice any profession or to carry on any occupation, trade, or business. However, the reasonable restriction of Article 19, Clause 1, Subclause G is prescribed under the Article 19, Clause 6 in the interest of general public. Your Lordship, on page 15 of the Moot Memorial, in Bombay Hawkers Union versus Bombay Municipal Corporation, AIR of 1994, the Supreme Court observed that if the nuisance and inconvenience was spread by hawkers in public, then they should be removed. The restriction on the occupation or profession under Article 19, Clause 6 was held liable, and similarly, in this present case, if the people in the provision of the service in which they have to interact with the public at large do not take vaccine and travel around, and then it will create the inconvenience to general public, and danger of spreading the virus will increase more to the public. So in this case, also the restriction of the fundamental right, 19 Clause 1G, is reasonable in order to curb the spread of the virus from general public health, from general public.
Yes, what else?
Your Lordship, it is also raised by the petition that the mandatory vaccination is the violation of the right to privacy of an individual enshrined in Article 21. On page 14 of the memorial, it is held by the Supreme Court in the case of the Ritesh Sinha versus State of UP, as my co-counsel has also mentioned this case, that the right to privacy is not an absolute right, and that fundamental right to privacy must bow down to the compelling public interest. And state also had an obligation to improve the public health under the Article 21. With reference to all arguments, Your Lordship, the council contending in this honorable court that the act of the mandating the vaccine by respondent is in order to protect the public health interest at large, and decision taken by the state was as per the instructions of the central government. The respondent humbly submits that this decision of mandatory vaccination for various activities or provision of services is legitimate. If Your Lordships are satisfied with the arguments of the issue number 2, the council seeks permission to proceed with the arguments for the issue number 3.
Yes, please.
Much obliged, Your Lordship. The issue number 3 is whether the MHA order that led to the migrant crisis was arbitrary, disproportionate, and violative of the fundamental rights. Your Lordship, the order council referring here under the issue is the order of MHA issued on 24th March 2020, under which it was held that the National Disaster Management Authority is satisfied with the threat of the virus. Therefore, to curb the spread of the virus, a 21 days lockdown was announced and imposed on the 25th March of 2020. To deal with this particular issue, the council wants to make 3 submissions. Firstly, the announced lockdown was not arbitrary. Secondly, the announced lockdown was not disproportionate to migrants. And thirdly, the announced lockdown was not violated to the
Council, your voice is cracking.
Council will make that the announced lockdown was not arbitrary. On page 10, second largest population in the world, and WHO.
Pardon, Your Lordship. There's some network issue.
Please inform.
I'm sorry, Your Lordship. Pardon me for the
yes
inconvenience.
Yes, we can hear you.
I would like to refer to my co-counsel that where I live.
Yes, you were dealing with the last issue. I believe you were telling us what are your arguments regarding the same. Please continue.
Did I conclude it?
No, we couldn't hear you.
Okay. So my last submission was that the petitioner is also raised that the Article 21 was violated here under the right to privacy. On page number 14 of the memorial, as my co-counsel has also mentioned this case of the Ritesh Sinha versus the State of UP, the right to privacy is not an absolute right, and that the fundamental right of privacy must go down to the compelling public interest. With reference to all arguments, Your Lordship, the council contending in this honorable court that the act of the mandating the vaccine by respondent is in order to protect the public health interest at large, and the decision taken by the state was per the instructions of the central government. The respondent humbly submits that the decision of mandatory vaccination by the states is not for the various activities or provision of services is legitimate. If your lordships are satisfied with the arguments for the issue number 2, the council seeks permission to begin with the issues for the arguments for the issue number 3.
Yes.
Much obliged, your lordship. The order council referring here under the issue is the order of MHA issued on 24th March 2020, under which it was held that the National Disaster Management Authority is satisfied with the threat of the virus. Therefore, to curb the spread of the virus, a 21 days lockdown was announced, which is imposed on the next day of 25th March 2020. To deal with this particular issue, the council would be making 3 submissions. Firstly, the announced lockdown was not arbitrary. Secondly, the announced lockdown was not disproportionate. And thirdly, the announced lockdown was not violated to the fundamental rights of the migrants. Your lordship, the council wants to make first submission that the announced lockdown was not arbitrary. On page 10, para 1 of Moot proposition, it is mentioned that the Celexa has the second largest population of the world, and WHO announced COVID-19 as pandemic since it was highly transmissible and deadly virus. WHO also clears on their website that the spread of the virus mainly happens more when the people are in the close contact. The virus spread faster in a crowded setting where people spend a long time. Since there was no availability of the vaccine in the country at that time, or any other measure through which the fast spreading virus can be halted, so the last resort the government has is to impose the lockdown. The National Disaster Management Authority announced the lockdown because under Section 6, Clause 2, Subclause I, Disaster Management Act of 2005, the national authority may take such measures for the prevention of disaster or the mitigation of preparedness and capacity building for dealing with the threatening disaster. According to Section Clause 2 of the Disaster Management Act of 2005, the COVID-19 pandemic is a disaster because it caused substantial loss of lives. The government also plans to lock down in order to flatten the curve of the increasing number of infected patients of the COVID-19 virus. So by restricting crowd and creating social distance among people through 21 days lockdown, the government will get time to prepare the health system to cope up with the large number of sick patients and can also plan for the future. Your lordship, the council wants to make submission that the next submission that the announced lockdown was not disproportionate to migrants.
So wait a second.
The lockdown.
Let me understand.
Yes, your lordship.
When was this lockdown imposed by the government?
It was imposed on the 25th March of 2020.
And this was imposed only when the WHO declared as a pandemic?
Yes. Firstly, WHO declared that it was a highly transmissible disease and it is a pandemic. Then the government took the decision to. Sorry, Lordship, can you clarify your question?
When did this happen? When did the WHO declare it as a pandemic?
WHO, according to the facts of the case, is also declared it in the month of the March 2020 that it is a pandemic.
So, what is the study that the government has done on this particular issue?
The last resort, the government has to put the lockdown, but before the government cannot put the lockdown before any higher medical authorities clarification that is a highly transmissible disease and it is a pandemic. Because if the government put the restriction before any clarification, then there will be also the chances that the petition will come on this regard that on what basis the government is putting the lockdown when there is no clarification, any medical authority given that it is a highly transmissible disease or it is a pandemic. So that's why the government.
My question is very simple. I'm not concerned as to what the petitioner might say and not. In the interest of the public at large, you sure have your own departments as well, the ones who look into the same aspect. Is there any relation, like any data that you have from your own departments? Or are you just buying the argument of the WHO? What preparations have you made on your behalf? Have you taken the WHO as like their own gospel truth?
Shall I proceed? Can I answer this?
Yes, please.
Yes, Lordship. The order the WHO announced on 24th March of 2020. Along with that, the annexure was attached also in that order, in which the government's plans was there that what we will do in this process of 21 days lockdown, and how will they going to manage the country in this nationwide lockdown of 21 days.
I still haven't got the answer. You may continue.
Thank you, Lordship. Much obliged, Lordship. Next, the council wants to make the submission that the announced lockdown was not disproportionate to migrants. The lockdown was not disproportionate action because, according to the doctrine of the proportionality, asserts that there must be a reasonable nexus between the desired result and the measure taken to reach that goal. And here the desire of respondent is to protect the public health interests at very large and provide safety to everyone by reasonable measures to reach their desired goal. The order issued by the MHA on 24th March 2020 was neutrally worded without forming any section of society, without favoring any section of society. And the first priority of the government was to curb the spread of the virus and to ensure that no public movement can take place. Under Article 47 of the Constitution, the state has the duty to improve public health. On page 18 of the memorial, the migrant crisis was an unprotected situation, but steps were taken by the government for migrant workers in order to ensure that lives are not threatened by the situation of the pandemic. If you also can refer to the page 18 of the memorial, then then there are many facilities which were provided to the migrants when the crisis was happened. So firstly, the transport facility provided to them when there was restriction on movement and suspension of transportation were there. In the order of MHA on April 29, it was allowed to states to coordinate individually to transport migrant to use transport buses so they can transport the migrants to their respective homes. And the Indian Railways resumed passenger movement and special Shramik train facilities provided to migrants so they can reach to their respective homes. They transported 58 lakhs of migrants by operating 4,197 Shramik trains within just 1 month. The next food facilities were provided.
Your time is up. We can see in the chat box. You can wrap up.
The council seeks permission to exceed the time for just 2 minutes.
Subject to what my brother judges think.
Yes,
No, I think you may conclude in 1 minute by answering one question. You're telling us that you provided the facilities and all those things you did, but I'm wondering that why did people still die? I mean, they were committing suicide on the roads or what? Because if you were so good in providing the facilities, and be it the transportation or the food, but then why did the people die? Why there were so many deaths reported? That's number one. Number two, why did people go, right? Don't you have a facility in their respective workplaces that they should actually stay in those cities where they used to work, right? Why there was a circumstances, why you compel them that they should go, right? Why did you create that kind of circumstances? That's what I wanted to know, right? So why don't you create those kind of facilities that they should stay in those kind of places in those cities itself, right? Why that situation had to come? So that thing need to address, and this shows that you were not prepared regarding my point, and it shows that it was an unintended, unplanned order which you need to address. I mean, do you have anything to say? And just wrap it up.
Your Lord, yes, Your Lord. Indeed, Your Lordship. The plan was not unplanned, as I mentioned that on 24th March, MHA announced order. There was an annexure that they have made the plan for this, but the migrants were at the small proportion in the country, and the government was seeking at the large.
You said it was planned. Okay, where is the blueprint? Is there any blueprint available? Did they meet what they have decided that okay? Did they foresee that okay, this would be the outcome? This this okay, that amount of people would be on the roads?
Yes, Your Lordship. Yes, indeed, Your Lordship. But as I said, that the migrant crisis was unpredicted because they are at the small in proportion, and government is seeking at the large public health to protect large public health. And but when the migrant crisis happened, it's not like that the government took their hands off from them. They provided them with the facilities, the best as they can do for them.
Okay.
I want to.
Yeah.
The council wants to make the last submission that the announced lockdown was not violative of the fundamental rights. The Lordship petitioner is claiming that the announced order has violated the fundamental rights of migrants to move freely throughout the territory of the country under Article 19, Clause 1, Subclause D. But under the Article 19, Clause 5, the restriction was provided of the Article 19, Clause 1, Subclause D. And on page 19 of the memorial, in case of Narendra Kumar and others versus the Union of India, the Supreme Court held that the restriction must consider the background of situation that has occurred, and the reasonable restrictions should remain reasonable and not cross the line. And in this lockdown announcement, the restriction is reasonable as it imposed in order to protect the public health interest at large, and the government has only a last resort of lockdown to curb the spread of the virus. With this, the council is done with their arguments, and if the Lordship are satisfied, yes, the Lordship, the council wants to make the prayer. Wherever in the light of issue raised, arguments advanced, and authority cited, it is humbly prayed that this honorable court find that there is no expediency to invoke the jurisdiction of this court in this present case. Therefore, dismiss the if the Lordship provide me.
You can simply pray for dismissal of the petition. That's all. You don't need to make your prayer so elaborate. You can simply pray the petition may be dismissed, and you can even ask for imposition of some costs.
You don't need to flip the pages, right? I mean,
I really apologize. I really apologize.
If you've forgotten it, your co-counsel can pray.
I'm praying. I'm praying, Your Lordship. I really apologize for my behavior. I really apologize. So council asks for the relief that hold the Union of Selexa liable for the violation of the fundamental rights of people and for arbitrary and disproportionate decisions taken by them. Hold the Union of Selexa liable for the death of the migrant workers and for the people who lose their jobs. Order and direct the government to take corrective measures in everyone's favor. And lastly, pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience.
Thank you.
Thank you, Lord.
Thank you.
Thank you, Your Lordship.
Thank you. Courtmasters, are we done?
Yes, sir. And Your Lordships, with your kind permission, I'd like to bring it to your notice that the Council 1 from Team K had exceeded his time by 7 minutes. And for the Team G, the Council 1 had exceeded by 1 minute and the Council 2 by 9 minutes.
That's fine. All
Thank
right.
you.
Thank you. Can we leave the meeting?
If I would like to request your Lordships to provide feedback to both the teams.
I think Dr. Farooqi can go first, sir.
No, I think I would be a little biased because I can see some of the faces which are familiar to me. So, I mean, they have been my student. I think a little, little sad to see because I was expecting a better performance, but that's okay. I mean, it's a competition. You can always have a space to grow, but that's okay. I mean, but I think I was expecting a better performance when it comes to particularly the court manners and court mannerism, which I have been focusing when we started this way back, because this There's one team, I don't want to name them, but it belongs to one of the senior most batch, I guess. Not senior most, but the second senior batch. So I don't know why you people made those kind of mistakes. The other batch, I don't know much about them. So it's just the court etiquette's mannerism, which was not that much evident. That's the one thing. The second thing is, of course, the coherence, or when you are arguing yourself, when you were making the argument, the first thing which I saw is that I mean, it looks very disjoint. Even when I was reading your memorial, and even when you are arguing in person, I mean, it looks very, there is no sequence in the first argument, in the first sentence, or in the second sentence. So it seems very disjoint to me. So you need to bring that kind of a sequencing, or maybe coherence between the two things. So this is what you need to understand. I think you have that. I'm sure you have been doing this, and you have had that kind of internship experience while working with lawyers also. So I don't know why you have made that kind of a mistake. Anyways, but everything is a learning process. I'm sure you will learn from it also, and my other fellow judges would also share some kind of experience with you, and so it's a good experience altogether. But certain things you shouldn't have done, but that's okay. You did it. You all learn from it. That's okay. That's okay. I think I need to go somewhere. So can I leave now, Burhan Sahab? Is Burhan Sahab there? Or?
Yes. Sir, thank you so much for your time. Yeah. We're anyway ending the meeting. Thank you so much. Yeah, thank you so much.
Thank you, Dr. Farooqi. It was a pleasure.
Yes. Same here, Sikandar Saab, and whenever I'm in India, would love to meet you.
Definitely, we'll catch up with you. Definitely.
On behalf of Moot Court Society, I would like to thank Dr. Mohammad Uwais Farooqi, who was an assistant professor at Jamia Hamdard University and is currently with University of Sharjah. He has been a constant motivation for all of us. Thank you so much, sir.
Thank you, beta. Take care.
Mr. Cole, you would like to go ahead?
I'll just elaborate slightly more onto what Mr. Farooqi had to say. What we understand is, like, in any of the court proceedings, a lawyer, whenever asked a question, has to answer first and foremost.
Correct.
You really can't take a step and say that I'll answer this later. So that needs to be in check. And one has to have, again, the same coherence. Like, one needs to know what exactly is the case at hand. You have to stick to it. You can't be going out of the box. So one needs to, like, stick their guns to the point, to the target. And again, like, it's hard work. It goes on for some time. Not many years to put into practice. A positive way to go ahead. I'll just keep it short. That would be all.
Thank you, sir. Can I go ahead, Court Master?
Yes, Your Lordship, please.
Yes. So adding to what my colleagues, Dr. Farooqi and Advocate Rohit Kaul said, see, when you are arguing in the court in the first place, you have to use formal language, which I found missing from both sides. Both sides were responding by saying, okay, you always refer court as third person. You can never refer to court as first person. Like, both sides said that you may refer to this page. You cannot say you may refer. You have to say this court may refer, the bench may refer, or your lordship may refer, or your honor may refer. First person has to be avoided. You can't refer to court as first person. That is first. Court etiquettes, you can little bit improve on court etiquettes. And as my brother judge, Mr. Kaul said, that when a judge is asking you a question, apart from answering it then and there, you have to listen. I found it missing in some speakers from both sides. When a judge is asking you some question, please listen to what a judge is asking, and don't try to beat around the bush. It doesn't cause you any harm if you say counsel pleads ignorance. I don't have any case law to back this, or I don't know the answer to this. I plead ignorance. It doesn't do you any harm, as does beating around the bush. Judge is asking you something, you're answering something else. So it does more damage than any benefit to you. And apart from that, see, the Moot problem, according to me, and I think Mr. Cole will agree with me, it was very simple. You didn't need to back it by a lot of cases from Constitution and all. Even if you would have hit up on Live Law or any other, legal website regarding all these PILs which were filed in different high courts and the suo motu petition before the Supreme Court, you would have found written submissions of the union as well as the petitioners, wherefrom you could have drawn your arguments, But I found it missing from both sides that you couldn't cite any recent judgment. What did ultimately court held? I was, the Kerala High Court recently came up with this judgment regarding mandatory. It's a case from there where this teacher was suspended. So they passed a judgment in this regard. So you would have hit up Kerala High Court, COVID vaccination, you would have found this judgment in the first place. So I think research was a little bit missing. Overall, since it's a competition, as my brother said, there is a lot of scope for improvement. It's a good way to start. You both had, memorials were very well drafted, but of course the coherence was somewhere missing. But of course you can improve on these fronts. So with this, I would like to conclude and wish you all the best.
On behalf of the entire Moot Court Committee of Jamia Hamdard, I would like to thank Advocate R.J. Sikandar, who is a practicing advocate at the Honorable Supreme Court of India and Delhi High Court. Advocate Sikandar is also a guest lecturer in various colleges across India. And Advocate Rohit Kaul, who is a practicing advocate at the Honorable Supreme Court of India, Delhi High Court, and various district courts and tribunals, for taking time out from your busy schedules to judge the final round of first Intra Moot Court competition. We are really honored and grateful for your presence, sir.
We are also really honored. Thank you so much, Mr. Burhan.
Yeah, Advocate Reis, Advocate Cole, thank you so much for your time. It was a pleasure to host you.
Pleasure.
Thank you. Take care, please.
The score sheet has to be sent at.
Yes, we'll have to send it over the email.
Yes, sir.
Yes. Have a great evening, Mr. Cole. Have a great evening, all of you.
Have a good
Thank you.
Everyone. Bye-bye.
Bye.